Yes.
In respect to item number 6, concerned counsel is due to some problem, they cannot attend the court. Accommodation not possible for the matter for the day only.
Item number?
6.
Yeah, for the respondent.
The petitioner counsel could not attend the court.
Mr. Goswami,
Malam.
your initial is?
UK Goswami.
Mr. UK Goswami, learned counsel, submits that Ms. M.S. Jayadeka,
Malam.
learned arguing counsel in the matter due to some personal difficulty, could not
Attend the court.
attend the court today and accordingly seeks a short accommodation. Other side is there?
But,
Yes, higher education.
I will inform my lord.
You should have informed before making a mention.
Malam.
What is this, Mr. Goswami?
I thought, Mr.
Yes, anyone there? SK Sinha, A Thakuria, BTC. Any objection? Mr. SK Sinha, Learned Counsel, appearing for the respondent number 5, does not oppose to the said prayer. Relist
Well, next.
after a week on a date to be fixed by the registry.
Highly obliged.
Made please, Lordship. I beg to make
Please do not make any mention before this court without intimating the other side. Informing the other side. Yes.
42, my lord. I am paying for a little accommodation for today, my lord.
Item number
42. It's a review preferred by the state, my lord. Maybe come on
40.
42. Maybe taken up on Monday, my lord.
As prayed for by Mr. N.J. Khatonier, Learned Counsel, appearing for the review petitioner, relist on such and such date. Yes.
May I
Obliged.
please, your lordship? Lordship, regarding item number 43 and 44,
Yes.
they have given an affidavit, so we have to go through it, and we have to
40.
43 and 44.
Is this yesterday's matter, Mr. Sharma?
No, my lord.
No.
That is the my lord university's matter.
Okay. Item 43.
Yes.
Who has filed affidavit? You have filed.
Yes, my lord. We have filed it last week, my lord. That's
All right. You want to file a
Reply affidavit.
after 2 weeks.
Lordship, kindly possible in 17.
Mr. Your name.
RC Alam.
As prayed for by Mr.
RC Alam on behalf of
Alam, the Learned Counsel, appearing on behalf of
PJ.
Mr. P.J. Fukan, Learned Counsel for the applicant in the IA, in so-and-so. Relist after 2 weeks on a date to be fixed by the registry to enable the applicant to go through the affidavit filed on behalf of the respondent stroke petitioner. Correct? And file a reply if so advised.
My lord, prepare the note that your lordship had directed.
Yes, please.
Yes, okay.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 2, lordship. They have filed an affidavit in opposition. You would like to file a reply to that, lordship.
Item number?
2, lordship.
My lord, I have objection to this, my lord. Matter is pending for a long time. my lord.
But you have filed something.
Yeah.
What
We
have you filed?
In 2022, my lord.
You have filed in 2022.
Yes.
Wait. Yes, next.
May I please, Your Lordship, I beg to mention for item number 38,
30?
on the behalf of 38
But the question.
Yes. What do you want?
for a day.
My lord, in this case,
But-
my lord, my only prayer, my lord, since the whether it's urgency since 2013, my lord, I have been deprived from the provincialization, my lord. 2001 order, they filed a review 2024.
As prayed for by MS
That should be
Kedas.
fixed, my lord. Next.
Kedas, Learned Counsel, appearing
Okay.
on. Huh?
B. Kaushik, Lordship, on the behalf of.
No, your name.
P. Lamu.
P. Lamu, Learned Counsel, appearing on behalf of Mr. B. Kaushik, a relist on such and such data that they
Kindly,
did.
my lord. Next.
Yes, next.
17 or 18?
Lordship, I beg to mention item number 17, Lordship.
Hmm?
Item number 17, Lordship. Kindly adjourn for the day, Lordship. I already informed the opposite party counsel, Lordship.
You are for?
B.U. Lashkar, respondent, Lordship.
As prayed for by Mr.
B.U. Lashkar.
Your name.
B.U. Lashkar.
Mr. B.U. Laskar, Learned Counsel, appearing for respondent number 7 with consent from the other side. Relist after 2 weeks on a date to be fixed by the registry.
Lordship, apply.
May it please your lordship. Lordship, in regard to item number 35, we have filed an additional affidavit, your lordship. Lordship may kindly call for the
Okay.
additional
All right.
along with the obliged.
Next. You give a requisition to the court master. Miss, call the list.
Supplementary list, item number 47, authorized executive.
Lordship, in this case, Your Lordship, stay vacating application has been filed, Your Lordship. I want to file a short reply, Your Lordship. Maybe taken up on Monday or Wednesday, Your Lordship.
Monday, the objection might not be on record if it's filed tomorrow. So let's be on Wednesday. Lordship.
As heard, Mr. P. Bharadwaj, learned counsel appearing for the applicant. Also heard Mr.
Yes, water.
S. Borthakur, learned counsel appearing for respondent number.
For the opposite party number 1 in the IA.
For the opposite party number 1 in IA so and so. Mr. Borthakur seeks a short accommodation to file objection to the interlocutory application. Prayer is allowed. Relist on Wednesday, time to
Lordship,
date.
maybe 18th, Your Lordship, 17th, I will be out.
So and so.
Okay.
Deeply obliged.
For admission, item number 1.
Suspension, Mr. Chaudhary.
Yes, yes. Some lengthy matter was heard.
I don't remember.
The
Ajay,
facts-
I think this matter was heard long back.
Yes.
After seeing Ms. Bhattacharya, I have.
Milord, facts
I-
are on a very, very narrow compass, Milord.
Ah.
Now, what had happened? The petitioner was placed under suspension on 30/12.
30/12/2023, show cause notice on 1/3/2024
Yes.
expires that 90 days, na?
No, that is the okay.
No, no, no.
But
I'm
review was
just,
not done.
I'm just checking.
Huh.
Expired on 29/3/24, right?
Yes.
And then the extension came on 28/6/2024.
Yes.
That is after the
90
expiry,
days.
after the expiry of the 90 days. That is the facts.
That is the only.
And they are relying on who's relying on this OM 4220?
They are relying.
What is that OM?
Lordship, in this OM, I don't have this particular copy with
Huh?
me right now. Lordship, here, if the charge sheet is filed within 90 days, Lordship, then the review after subsequently.
No,
within
but the
6
charge
months,
sheet was
Lordship.
not filed.
If the charge sheet is filed within 90 days, Lordship.
When was the charge sheet filed in this case?
1/3/24.
Show cause notice.
Yes.
No, that was filed within the 30/12/23, right? No.
Milord, there also there is a dispute, Milord. I think if it is 30/12/23, then I think 90 days will be, Milord, 29/3.
Correct. So before that, 1/3/24.
Oh, sorry, Milord. Sorry. Because February would be.
I have these
28
dates because you had given me these dates.
No,
huh?
February would be 28 days. Therefore, it was within 90 days.
So that is within 90 days.
Yes.
Yes. Only thing is that this is the
The
show cause notice.
Review was beyond, Milord, 90 days.
Now,
Because Ajay Chaudhary says even if the charge sheet is filed within 90 days, there
Ajay
is still
Chaudhary,
a requirement of, Milord.
a review.
Para
Now,
21.
now suppose a charge sheet is filed within the stipulated time.
Yes.
However, the
Review
review is
is not done.
not done.
Then also it will attract the vice of.
Which is that decision?
Ajay Chaudhary, Milord, para 21.
What does Deepak Mali says?
Same thing.
And-
Deepak Mali, same thing. I think the judgment must be on file.
Deepak Mali, just a small submission. Deepak Mali is actually based on CCS pension service rule. Lordship.
Ms. Bhattacharya, I am not going to dispose this matter after hearing Mr. Chaudhary. I am yet to hear you.
Milord, Deepak Mali reiterates the proposition laid down in Ajay Chaudhary.
Yet pilot kintu nai de hearing it.
Ajay Chaudhary would be, Milord.
I have a copy.
Yes, please come to para 21.
Para?
21 at page 303.
Itu beya. Itu bhal copy dibole diyo. Do you have any extra copy of Ajay Chaudhary?
Yes.
Ekhon video ছিল। Into beya. Yes.
Para 21, Milord. We therefore direct that the currency of a suspension order should not extend beyond 3 months. If within this period memorandum of charge sheet is not served on the delinquent employee, if memorandum of charge sheet is served, a reason order must be passed for extension of the suspension. So this is the mandate. Deepak Mali is in the context of CCS, CCA rule, there is no doubt about it. Even our Millard departmental instructions also says so. Manual of
One second. Any other authorities or rules you want to rely? What does?
Yes, Millard. If your lordship would kindly have our Assam's own rule, Millard.
Yes, Rupak Diba rules.
এখন কিতাব দিন না। 2.1.8 লিখি না? Now, if your lordship would kindly have this book, Millard, page number 59. In fact, Millard, this Ajay Chaudhary is an authority of Millard 2015, whereas our state circulars are of 1978. Please come to page 59, Millard.
Yes.
2.1.8 in that book.
Yes.
Following principles and procedures with regard to suspension need strict compliance. Suspension should be resorted to only in cases where a major punishment is likely to be imposed if charges are proved. This is the first guideline. Second, charges and statement of allegations should be served within 3 months from the date of suspension, failing which the government servant concerned should be reinstated. Now, 3. In case where it is not reasonably practicable to prepare charges for this service within 3 months from the date of suspension, and continued suspension of the government servant is considered necessary in public interest, the authority concerned should move the personnel department to administrative department well before expiry of the period of 3 months with a letter detailing the nature of the allegation and reasons for which charges could not be prepared, so that personnel department could advise whether any further extension of the period of suspension should be permitted or not. Let us not go to others, our own circular, Millard. So idea is,
What does this and would mean here
which part, Millard?
in that sub clause 3?
And nature of the allegation and reasons.
No. In cases where it
Huh.
is not reasonably practicable to prepare the charges or
Within
service
3 months from
within
the date
3 months from
and
the date of suspension and the
continued suspension of the government servant is considered necessary in public interest.
So what does this and mean? Together, it would mean both inclusive?
Both.
Both.
In fact, this is what has been emphasized by Millard Ajay Chaudhary now. In fact, Millard Ajay Chaudhary raised one very.
However, in your case,
Yes.
the charges have been framed
But
within
the review was not done.
within the prescribed time. Only thing after the suspension period lapsed, at that moment they did not extend it with a reasoned order, which was done subsequently. And that is a reasoned order.
And Millard, if your lordship would kindly have Ajay Chaudhary for one moment, Millard.
Yes.
Now, two things are very significant in Ajay Chaudhary.
Yes.
First, Millard, I was reading para 21. If
Yes.
your lordship would kindly come between placitum D and E, the sentence starting with, we recognize.
Yes.
We recognize that the previous constitution benches have been reluctant to quash proceedings on the ground of delay and to set time limit to their duration. Yes. So, Malad, this is the first time the Supreme Court came up with this proposition, Miller. Now, if your lordship would kindly come to this principle has been borrowed from a CRPC section 167B, Miller. It's a legal fiction now, and it's like a default bail. If the charge sheet is not filed within 90 days or 60 days, as the case may be, an accused is entitled to bail. Same principle has been borrowed and followed, Miller. I think I'll just place that part, Miller. So here, Miller, there is no scope of any argument.
Mr. Chaudhary, if I have understood you correctly, the short question that falls for determination in this writ petition is whether, despite of issuing charge sheet within the
Stipulated
stipulated time, non-extension of the suspension period by a reasoned order within the, before the lapse of expiry of the time period would entitle,
Render the suspension bad in law.
would entitle automatic reinstatement.
Yes,
Is that the question?
that is the question.
So let us focus on that.
Precisely, Miller. That is the point. Yes, Milord will kindly come to para 20, Milord, of Ajay Chaudhary.
Yes.
It will be useful to recall that prior to 1973, an accused could be detained for continuous and consecutive period of 15 days, albeit after judicial scrutiny and supervision. The Code of Criminal Procedure contains a new proviso which has the effect of circumscribing the power of the magistrate to authorize detention of an accused person beyond the period of 90 days where the investigation relates to an offense punishable with death, imprisonment for life, or imprisonment for a term of not less than 10 years, and beyond a period of 60 days where investigation relates to any other offense. Drawing support from the observation contained in the division bench in so and more so the constitution bench Antulle, we are spurred to extrapolate the quaint essence of proviso to section 167 to CRPC to moderate suspension orders in cases of departmental and disciplinary inquiries also. So, my lord, virtually, my lord, this proviso to section 167 to CRPC has been extrapolated. So here, my lord, there is no scope of any argument. As like, my lord, if the charge sheet is not laid within 90 days, the accused is as of right entitled to bail. Only thing is, he has to give a bond.
Default bail.
Default bail. Same principle will apply. Here there is no scope of argument, my lord. Because every day we are getting this type of cases and there are innumerable cases. Only thing is whether charge sheet was filed and the review was done within 90 days. So in my humble submission, my lord, facts are clear.
That's all?
Yes.
Yes.
My lord, to lordship's kind permission, I have a matter in court.
Yes,
for
yes.
2 minutes. Yes.
Lordship, our stand in this matter is that, Lordship, the show cause has been issued to the petitioner within the stipulated
stipulated.
90 period days time, Lordship.
Where is
So-
the extension? That review?
Lordship.
28/6/24, right? Which page?
Yes, Lordship, 27/6/24, Lordship.
Not 28.
No, this is,
I had written it down, so I may be wrong.
not 20.
You let
No,
us go
Lordship,
see and
there is a time, maybe.
let's
Lordship,
go-
this
let's
is
go-
page 106, Lordship.
page
6, Lordship.
106.
And exact 2, Lordship.
Yes, 27. You're right.
Yes, Lordship.
27.
So it was extended.
After
Lordship,
90 days.
after 90 days.
Can you
Lordship,
read
in
it?
this case, Lordship, we.
Let us, Ms. Odyssey, let us read it. Why are you getting so
Yes, Lordship.
anxious?
The Lordship.
Let's read this, page 106.
Yes, Lordship. Whereas Sri Samsul Haq Talukdar, the then Lakmandal of Boitamari Revenue Circle, Bangaigaon, was placed under suspension with effect from 22/12/2023 by letter number so-and-so dated 30/12/23. Whereas departmental proceedings were initiated against so-and-so the then Latmandal of Boitamari Revenue Circle, Bangaigaon, Bhai, order number so and so, shows notice dated 1/3/2024, Lordship. Whereas departmental proceeding was drawn up against Sri Shamsul Haq Taluk.
Now, where is the 1/3/24 show cause notice?
This is the,
This is.
this I think they have annexed here, Lord.
Yes,
in the
just give me
Lord, 1 minute.
page.
Lordship, this is in page 89 of the writ petition.
Page 89. Yes. 89, right? Yes.
This is.
5 copies, page 87.
That's what I was trying to find out. This copy is very.
Basic,
Ah,
Lordship.
87.
Yes,
87.
sir.
Thank you. This is 1/3/24.
This is addressed to the petitioner, Lordship. Show cause, you are hereby required to.
And
show cause.
suspension is? Which page is the suspension?
Lordship, this is page 86, Lordship.
I think these are the 3 documents. Yes.
Yes.
Now tell me.
The information was received, he was done suspended.
What do you have to respond to the arguments made by the Learned Senior Counsel as far as the Ajay Chaudhary case is concerned?
Lordship, Ajay Chaudhary case, because on that particular ground, Lordship, I want to rely the office memorandum that was issued and which has been
Which office
actually
memorandum?
issued on the basis of the direction passed by this honorable
Which
court,
is
Lordship.
that office memorandum?
This is 4th February
Give me a
2020
copy.
office memorandum, Lordship.
For February.
4th February 2020.
There is nothing.
We handed over, Lordship, on last occasion.
That doesn't. It will keep us. Give it to them. What are these papers? Can you not get hold of a better copy?
Lordship,
Huh?
actually, this is available in the website also, same, Lordship.
How can this be available in the website?
It is
Huh?
available in the website.
Yes, Mr. Gautam, do you have a better copy of the OM 4/2/2020?
I have this single copy.
If I
How
can,
come you did not get hold of this?
Lordship,
Huh? You are the government.
Lordship, may I read, Lordship?
Yes.
Office Memorandum. Honorable High Court Guwahati, in its order dated 30/11/2017, in a series of writ petitions, the lead case being WPC number 6465/2017, has directed to issue a notification indicating the law laid down by the Honorable Supreme Court in Ajay Kumar Chaudhary versus Union of India case to the effect that the disciplinary authorities are to strictly comply with the requirement to issue the memorandum of charges charge sheet before the expiry of 3 months from the date of issuance of order of suspension. It is therefore directed that all the senior-most secretaries of all the departments shall ensure that the memorandum of charge sheet is served on the delinquent officer employee before the expiry of 3 months of period from the date of issuance of order of suspension. They shall also ensure that the currency of the suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent officer employee. If the memorandum of charge sheet is served within 3 months of suspension, a reasoned order must be passed for the extension of the suspension whenever necessary. The officer proposing for suspension shall also ensure that the charges are framed and submitted to the disciplinary authority within 2 weeks from the date of passing order of suspension. After issuance of memorandum of charge sheet, the senior-most secretaries shall undertake a review within 6 months as regards the desirability.
I don't think rest is required. Required.
This paragraph is
Which
required.
paragraph?
After issuance of memorandum of charges / charge sheet, the senior-most secretaries shall undertake a review within 6 months as regards the desirability to further continue with the suspension order. So, senior-most secretaries will held responsible if cases of suspension in their respective departments are not dealt with and reviewed accordingly.
So this has been done within 6 months, you are saying.
6 months, Lordship. And in the meantime, Lordship, during the pendency of this, the petitioner actually retired from service, Lordship. This is also there.
He's retired.
Yes.
All right. Yes.
So, the Deepak Mali case that has been, Lordship.
They have not cited it today.
For the petitioners, they have cited,
Not
Lordship.
today.
The other day, today also they made some reference has been made, the
They have
principle.
They have not even said anything about Deepak Mali today. I am only recording what has been argued today.
Lordship.
Yes.
And so ours contention
I don't
is
think
that
you have referred to Deepak Mali today.
No, my lord. Yes. Senior advocate already submitted everything.
So that is
I
the
can
submission.
beyond that.
What has been
Yes.
submitted today, isn't it?
Yes, yes.
my question is that Ajay Chaudhary, that has been referred, Lordship. So this has been clearly dealt because earlier there are cases which has been dealt by this honorable court, Lordship, and on the basis of direction passed by this honorable court, this OM has been issued.
All right.
So the respondents are duty bound to follow the principles that has been issued by the government from time to time,
Alright.
Lordship. So we are on this.
All right. You are also there.
And there are, Lordship, there are other also coordinate bench judgment, Lordship, which has been, I have. Huh?
Yes.
Lordship, I just prefer.
Sudhir Kumar Paul.
Yes, Lord.
Regarding the review of 6 months, within 6 months.
Yes, where?
That is in clear, Lordship.
Where?
It's-
I was about to ask that only.
Yes, Lordship. That is
Yes.
relevant part starts from para 7, Lordship.
Para 7.
Para 7 onwards, Lordship.
Hey, Kamal. Yes.
May I read it, Lordship?
Yes, yes.
There is para 7, Lordship. There is no dispute.
Why is everyone standing?
Lordship.
Yes.
There is no dispute on the facts, nor there is any quarrel in the proposition of law laid down in Ajay Kumar Chaudhary, was reported in so and Deepak Mali, which were followed in Ajit Sonwal and Mrigan Haloi Chopra. In the office memorandum dated 4/2/2022 is still in force, which provides that memorandum of charge sheet must be served on the delinquent officer or employee before expiry of 3 months from the date of issuance of order of suspension, and it mandates that after issuance of memorandum of charge sheet, the senior-most
Just
secretary.
1 second. Don't know to be about it.
Senior-most secretaries will undertake the review within 6 months as regards the desirability for further continuation with the suspension order. In the facts of the present case, the petitioner was placed under suspension on 14/12/2023, and disciplinary proceeding was initiated against the petitioner by serving show cause notice on 1/3/2024. This show cause notice admittedly was served before expiry of 90 days, and the departmental proceeding had commenced pursuant to the issuance of the charge sheet. During the course of hearing, learned additional senior government advocate submits that before the before the court that the inquiry officer has concluded
What is the status of the inquiry here?
that department inquiry is completed, Lordship. It is before the pending before the higher authority to pass order, Lordship. On
Yes.
para 9, Lordship. In the present, in the judgment of Apex Court in Deepak Mali's Rule 10.6 and 10.7 of the Central Civil Services Rules 1965 were under consideration with respect to the suspension and the extension of suspension of the respondent therein. Under Rule 10.6 and 10.7 of the Central Civil Service Rules 1965, it is specifically prescribed that suspension shall be reviewed or modified before 90 days from the date of order of suspension. It is not reviewed. If it is not reviewed, then suspension will not be valid after a period of 90 days. However, such prescription is not provided for under Rule 6 of the Assam Services Disciplinary Appeal 1964. That effort pursuant to the order dated 10/11/20.
Ajit Sonowal is of this court,
This court, division bench.
division bench.
No.
You have a copy?
Yes. However, some clarification is not provided. That effort.
And Rekibuddin Ahmed is also division bench.
Division bench. Both these cases clarified that Rule 1 or Rule 2 will be applicable in other certificate. Other principle laid down in other certificates. Okay.
There is no appeal against this. Yes. That's all? Yes. You are Mr.
My lord, AK Azad.
Ajad. Yes, Mr.
In respect of my lord, office memorandum dated 4th February 2020, my lord.
Yes.
I would like to submit one thing, my lord.
Yes.
Digonta Kolta judgment, I think, is available in the report, my lord. Earlier that we have submitted.
Did you telecom details?
WBC 6827.
Whichever judgment you want to rely today, just mark it.
Well,
Fix it to 70.
Please.
Yes,
Para 25.
20.
25.
Yes,
This court is in respectful.
this is coordinate bench.
Yes, madam.
Yes,
This court is in respectful agreement with the reasoning as contained in the decision of the coordinate bench of this court in the case Prasanto Datta Supra. In the case of the Prasanto Datta, the coordinate bench of this court having recorded a categorical finding that at the time of issuance of the memorandum of charges and or immediately upon the memorandum of charges, charge sheet is served upon the delinquent, the disciplinary authorities is also required to apply its mind as regard the necessity to continue the suspension or not and pass a reason order as to why the suspension of the delinquent officer employee is to be continued. This being the mandate of law declared by the Honorable Supreme Court under Article 141 of the Constitution of India is binding as has to be followed in the letter and spirit. The implementation of the law declared by the Honorable Supreme Court in Para 21 in the case of Ajay Kumar Chaudhary Supra, in the state was so done by issuance of an office memorandum dated 4/2/22. This memorandum, this office memorandum relied today, my lord, by the state, my lord, issued by the Chief Secretary to the Government of Assam, personnel within bracket B department, wherein it was mandated that as follows, my lord. From this para, my lord, I want to submit, my lord, this the mandate framed in the Ajay Chaudhary cases, my lord, which was under Article 141 of the Constitution of India, and whether office memorandum can overrule that, my lord, mandate. That is
have
the
we
question,
challenged that office memorandum?
my lord.
Is that office memorandum under challenge?
No, my lord, we are not challenged that, but Honorable Supreme Court, my lord, decided this issue under Article 141 Constitution of India. Now I want to submit, my lord, whether state has the power to overrule that provision or not, my lord.
They have not
And-
overruled.
And
Ajay,
yes, my
even
lord,
this,
Ajay
in
Chaudhary
fact,
clearly,
this,
Ajay Chaudhary clearly, very much clear that the review has to be done within the period of 90 days.
it
But
says,
this
one
memorandum-
second.
My lord,
We therefore direct that the currency of a suspension order should not extend beyond 3 months. If within this period, the memorandum of charge sheet is not served on the delinquent officer employer. If the memorandum of charge sheet is served, a reasoned order must be passed for the extensions of the suspension.
my lord.
Now you see, this reasoned order must be passed for the extension of the suspension. It is not said that has to be simultaneously within that. It has to be understood that before the expiry of the suspension, a reason or a review has to be done. This is what Para 21 means.
My-
Para 21 doesn't say that if the memorandum is served, a reasoned order must be passed for the extension of the suspension along with the charge sheet.
No.
Because if suppose the charge sheet is filed within the time and there is no requirement of extension, why should they extend the suspension?
My lord.
You see, because within the 90 days period or the 3 months period, it may be so happen that things might finish. There may not be an occasion for extension. But suppose it doesn't finish, then the question of extension will come.
My lord. If come, then.
Are you following what I'm saying, Mr. Ajad?
My lord.
Yes, what you're saying is correct. The ratio is that if you are not being able to, the ratio basically is that the suspension has to be for a fixed duration. It cannot be for indefinite period.
My lord.
That is the basic principle,
My lord.
right?
My lord. Right.
Now, it also further enhances that you cannot keep a suspension for an indefinite period without issuing show cause notice or charge sheet. You must do it. And if you can't do it, then you have to give you have to review the suspension and reason why you are extending it. Second is that suppose within that stipulated period, the show cause notice is given, the charge sheet is given, but it has not gone to the logical conclusion within the stipulated period. Now, therefore, either you have to extend the suspension or you have to reinstate. You have to do one thing because you can't keep him. You cannot just keep sitting after giving the charge sheet and keep you under suspension. That also cannot be right. Therefore, this requirement that a reasoned order for extension.
Yes, madam.
But it doesn't say it has to be together. That is not there in Ajay Chaudhary. And the
actually-
OM clarifies.
Yes.
You see, the OM clarifies that yes, if suppose the charge sheet is given within the stipulated time, then within 6 months they will do a review. And after finding that yes, we need more time, they will give a reasoned order and extend. And in your case, admittedly, that has been done. Admittedly, there has been an extension after. I understand.
yes.
But within the 6 months of the OM,
Well,
and that OM is not under challenge before this court.
madam.
There is also a coordinate bench of this court, which court has already gone into that issue, which has been relied by the other side.
But in the Diganta Kolita cases, my lord, about this, I am already discussed. And after
Correct. You see,
discussion
there
about
is
that,
there is
my
nothing
lord,
contrary here.
Yes.
Both the coordinate benches
After
are
discuss-
saying the same thing.
After discussion, my lord, about the present OM, my lord, what relied by the state, my lord, the Digondo Kolita case decided in view of the, my lord, other Sudri judgment as mandate 90 days, my lord. That's why I am arguing, my lord. If we do that, Digondo Kolita case, my lord.
Yes.
In this case, my lord, already discussed about this OM, my lord. And after discussion, my lord, in view of the, my lord, 141 Constitution of India, my lord, I felt the provisions of the other Sudri case, my lord.
In this case, there was no extension in Diganta Kolita. What was the facts in Diganta Kolita?
The second part of the law mandate. Paragraph 29, my lord, Diganta Kolita.
The facts of Diganta Kolita.
Not here facts, my lord.
Where do I get the facts? This is relating to the Supreme Court case. Where are the facts of the? What were the facts? Because the decision is in the context of the facts of each case. What is the facts in Diganta Kolita?
Facts. Petitioner while working as
Yes, paragraph 3.
Paragraph 3, my lord. Petitioner while working as assistant engineer is a public works to the department of the work to even using on the obligation so level against the placed under suspension. On receipt of the detailed report data from the surrender police, which is not development information again in direction and suggestion for intersection. The proceeding, so I should begin the petition.
It says the suspension of petitioner not having been reviewed and no order in this connection issued to the petitioner Along with the show cause notice served upon him, he had instituted the present proceeding before this court on so and so, praying for an interference with so and so.
Then the
So
suspension.
there I
not
think it was
receiving
not
the-
given only.
Focus notice served upon-
That is the facts.
But law is, my lord,
All right, noted,
cited in the paragraph. 20.
noted, noted,
Paragraph 20.
noted. Yes. Anything else, Mr. Ajat?
One thing I want to point out is it, if you go by the facts of the observatory case, that case, since that search sheet has been filed, the court did not interfere.
21 paragraph.
21 and 22. That's it. Yeah,
22.
that's it.
All right.
That's it.
Sudhir Kumar Paul, my lord, what relied by my state, my lord.
Huh?
In the case of Sudhir Kumar Paul, my lord,
Which is Sudhir Kumar Paul now?
just relied by the state, my lord, my learned friend, my lord.
Yes.
In this case, my lord, the court not inclined to interfere with this case, with that case, my lord, due to the departmental inquiry was already completed. That is held in the paragraph 13.
I have seen.
My lord.
Even in your case, it has been completed.
But not final order till
No,
date.
here also not final order.
My lord.
Even in Sudhir Kumar Paul, not final order.
My lord.
During the course of the hearing, is that the disciplinary proceeding have been concluded and the matter is before the disciplinary authorities, but no final order has been passed.
My lord.
Same.
Yes.
Correct.
That's it.
Yes.
Heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. A. K. Ajad, learned counsel for the petition. Also heard M.S. M. Bhattacharjee, learned senior government counsel, right? The senior government, additional senior government counsel for the state, and Mr. S. Doctor, learned standing counsel, revenue and disaster management, so and so. Huh? By way of this petition under Article 226 of the Constitution of India, the petitioner is assailing the impugned order dated 30/12/2023 passed by the District Commissioner Bongaigaon, Assam, by which the petitioner has been suspended from his post of Lot Mondal of Boitamari Revenue Circle. The brief facts of the case is that in the year 2021, when the petitioner was posted as a Lot Mondal of Boitamari Revenue Circle in the district of Bongaigaon, Assam, and at that time one lady submitted an application through online for NOC in respect of a sale The said land was sold to a person, namely Anwar Hussain, in connection to the aforesaid sale. In the month of August 2023, one complaint was filed alleging the said land to have been fraudulently sold and in connection with the aforesaid complaint, a case being case number 29/2023 was registered by the circle officer wherein all the parties concerned were directed to appear before the circle officer. Thereafter, in connection with the aforesaid inquiry, a report was sought from the petitioner, wherein the petitioner, after duly verifying the application form, gave a report in favor of the sale. Correct? That is the facts. In connection with the aforesaid, a criminal case was filed being Jopi Hoga PS case number 292/2023 under section 120B, 420, 468, 471, 34 IPC.
Jogi Gopa.
Jogi Hopa. By FIR dated 10/12/2023, page 14 on Baba. In connection with the aforesaid case, the petitioner was arrested on 20/12/2023, and later on he was placed under suspension by the impugned order dated 30/12/2023. Stop. It is the specific case of the writ petitioner that despite the expiry of the statutory 90 days period, no review for extension of the suspension was done, for which the suspension for which the petitioner is entitled to be reinstated in service. Since the service of the petition, accordingly, the present writ petition has been filed. Stop. Mr. K.N. Chaudhary, Learned Senior Counsel, submits that since the review of the impugned suspension was not done within the currency of the statutory time period of 90 days, the impugned suspension is bad in law and the petitioner is entitled to be reinstated. Stop. In support of the aforesaid, he relies upon the decision of the Apex Court in the case of Ajay Kumar Chaudhary versus Union of India, so and so, reported in 2015, volume 7 SSC at page 291. He further submits that The coordinate bench of this court, in the case of Diganta Kolita versus the state of Assam, in WPC 6827 of 2023, has further, by following the aforesaid principles laid down in Ajay Chaudhary, Supra, has emphasized that the that even after issuance of charge sheet, the suspension cannot be carried over without the same being extended by a reasoned order
Within a period of 90 days.
within the stipulated period. Stop. That's all. This is your submission.
My lord. Period of 90 days, my lord, actually, madam. Stipulated period of 90 days.
I've said it. Period of 90 days. Kolana. Per contra, MS Bhattacharjee so and so submits that in the present case, the charge sheet was filed within the currency of the 90 days statutory period from the date of issuance of the impugned suspension order. And that within the 6 months period in terms of the OM.
To 2020.
Yes. So many things you all have given. I'm just trying to figure out where I kept that OM.
4 to 2020.
Only to put Golapur. OM dated 4/2/2020. And hence, no, full stop, huh? Mr. S. Datta. No, hated Nokoba. She further relies upon the decision of the coordinate bench. In the case of Sudhir Kumar Paul, you had given, na? Versus so-and-so in WPC 5623 of 2024. Mr. S. Datta, learned standing counsel, revenue so-and-so, submits that during the course of hearing, during the pendency of the instant writ petition, the disciplinary proceedings have been concluded and the matter is before the
Revenue and Disaster Management Department.
that is the disciplinary authorities.
That's it.
Before the disciplinary authorities, but no final order has been passed. He further submits that the petitioner in the meantime has also retired. Stop. That's all. That is what Mr. Datta you were additionally.
I will lend the Sudhir Kumar Paul judgment regarding.
That's all right.
Yes.
Okay. I have given my anxious considerations to the learned arguments advanced to the arguments advanced by the learned counsels appearing for the contending parties and have perused the materials available on record. I have also duly considered the case law cited in the bar. It is no, the admitted facts are that the petitioner was placed under suspension by order dated 30/12/2023 issued by the District Commissioner Bongaigaon for alleged involvement in a criminal case. Stop. Thereafter, on 1/3/2024, the respondent number, district commissioner is respondent number?
Lordship, respondent number 3.
Thereafter, the respondent number 3 issued issued show cause stroke charge sheet under Rule 9 of the Assam Services Discipline and Appeal Rules 1964. Read with Article 311 of the Constitution of India as to why any of the penalties prescribed in the aforementioned rules should not be imposed upon him. Apt to refer to the show cause notice dated 1/3/2024, which reads as hereunder, quote unquote, page 27. And sorry, page 87. Reading of the aforesaid, it is apparent that in view of the alleged involvement of the petitioner in the criminal case, the petitioner was charged with negligence of duty, misconduct and breach of trust, which is allegedly unbecoming on the part of a government servant. Accordingly, he was asked to show cause by filing written statement within 7 days from the date of this, from the date of the issuance of the show cause notice. It further appears that the 90 days time period, why do you say admittedly here it is 90 days? Because of that OM. 90 days time period, where do you get it? Because of that. And under this OM, it is 90 days. No.
90 days.
90 days is the OM says 90 days. Admittedly, the 90 days time period as provided, as laid down by the Apex Court in Ajay Chaudhary Supra, as well as the OM dated 4/2/2020, issued by the Chief Secretary to the Government of Assam, pursuant to the directions laid down in the Ajay Kumar Chaudhary Supra, on 29/3/2024. Correct? Admittedly, till the expiry of the said 90 days period, there was no extension, there was no review or extension of the impugned suspension order of the petitioner. It was only on 27/6/2024 when
Be done on 27/6/24.
27/6/2024, on which date by order, no, it was Kibilikola. It was not. Admittedly, the respondent number 4 by order dated 27/6/2024 extended the suspension of the petition, extended the period of suspension of the petitioner for an additional period of 3 months with effect from 21/3/2024 or until further orders by a reasoned order. Stop. The short question thus is whether for not extending the suspension, the period of suspension, despite submission of charge sheet within the stipulated period of 90 days, comma, the suspension per se is bad in law. Apt at this moment, apt at this juncture, to refer to the OM dated 4/2/2020, which reads as hereunder, quote unquote, reading of the aforesaid office memorandum, which has been issued as per the direction, division bench direction. The 6465 is division bench.
No, that's a single bench.
As per the direction of the coordinate bench of this court, by judgment and order dated 30/11/2017, in a series of writ petition, the lead case being WPC number 6465 of 2017, and as per the principles laid down by the Honorable Apex Court in Ajay Kumar Chaudhary Supra, whereby strict instructions has been issued to comply with the requirement to issue the memorandum of charges / charge sheet before the expiry of 3 months from the date of issuance of order of suspension. Stop. It appears that all the senior most secretaries of all the departments were directed to ensure that the memorandum of charges / charge sheet is served on the delinquent officer / employee before the expiry of 3 months of period from the date of issuance of order of suspension. It further appears that they were further directed to ensure that the currency of the suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent officer employee. Stop. It further appears that they were further directed that if the memorandum of charges / charge sheet is served within 3 months of suspension, comma, a reasoned order must be passed for the extension of the suspension wherever necessary. It further appears that they were also directed that after issuance of memorandum of charges charge sheet, were also directed that the officer proposing for suspension shall also ensure that the charges are framed and submitted to the disciplinary authority within 2 weeks from the date of passing order of suspension. It further appears that after issuance of memorandum of charge sheet, the senior most secretaries were directed that they shall undertake a review within 6 months as regards the desirability to further continue with a suspension order. Stop. In the present case, admittedly, the charge sheet stroke show cause notice was issued to the petitioner within the currency of the 3 months period. It further appears that thereafter, within the 6 months period as stipulated in the OM 42/2020, the case of the petitioner, the suspension of the suspension of the petitioner was reviewed and was further extended. At this juncture to refer to the judgment of the decision of the coordinate bench in Sudhir Kumar Paul, wherein in a similarly situated facts, the coordinate bench of this court did not interfere with the order of suspension and stroke or extension, as the respondents therein have followed the timeline and the procedure prescribed in the OM dated 4/2/2020. Relevant paragraph of the aforesaid decision is reproduced hereunder for ready reference. Coordinate bench of this court decided judgment of this decided on Milicodian, decided on 12/6/2025 in so and so. So and relevant paragraphs (11) or 15. In the present case, also, admittedly, in the present case, also, the respondent has reviewed the suspension of the petitioner after the charge sheet having been submitted within the currency of the suspension period within 6 months in terms of the OM dated so and so. It further appears that the discipline it is also admitted. It further appears from the submission made by Mr. S. Datta that so and so that the disciplinary proceedings have already been concluded. However, the disciplinary authorities are yet to pass the final order. That apart, it is admitted that the petitioner, during the pendency of the instant writ proceeding, has also retired from service. In view of the aforesaid, I do not find any reason to differ from the view taken by the coordinate bench in so and so. It is absolutely clear that the respondent has adhered to the time frame as laid down in the OM so and so. As regards the submission of the learned counsel appearing for the writ petitioner, that the suspension, that the charge sheet ought to have stated the reasons for extension of the suspension in terms of para 21 of Azai Chaudhry is totally fallacious inasmuch as is not applicable in the facts of the instant case, inasmuch as in the facts of the present case, the petitioner that the charge sheet was filed, was submitted within the currency of the suspension period, and hence there was no occasion for the respondent authorities to extend the suspension period. However, after the issuance of the charge sheet within the 90 days period, time period, comma, in terms of the so and so OM, within 6 months, the respondent have reviewed the so and so and has accordingly passed a reasoned order. That being so, I do not find anything illegal or arbitrary. The writ petition stands dismissed, no cost. Sorry. You may not get the order today only, maybe by tomorrow, because I am going to edit a little bit. Huh?
At last, my lord, after completion of my lord dictation, one line I have like.
Yes.
My case may be also disposed of in accordance with the my lord Sudhir Kumar Paul. That is also investigation already completed. In accordance with that case, my case may be also disposed of, my lord.
All right.
My lord. My lord.
That last part of that paragraph,
Yeah.
you want it to be incorporated?
My lord.
Very well.
My lord.
That will be done. I think that says that it has only thing in your case, I cannot say reinstated.
Yeah, yes.
Because you have retired.
Yes.
But
Yes.
I can say that it should be completed
Yes, my
within
lord.
that
In
time
accordance
frame.
with the dispose of, my lord.
Yes, Lordship, there are other judgments also of different.
That I will clarify.
My lord, my lord.
Okay, Mr. Ajant, once the draft is ready, you can just have a look.
My lord.
Okay, from the court master.
My lord.
All right.
Masterful.
এইখিনি কিয় পাইছিলে একেলগে থক এই অজয় চৌধুৰী দীপক মালিটো তালৈ গুচি গ'ল নেকি ইয়াৰ পৰা উলিয়াই দিয়কচোন ইয়াত দীপক মালিটো ক'ৰবাত থাকি যাব ইয়াত লাগে মোক
Until number 2.
Lordship, they have filed an affidavit in opposition. We would like to file a reply to that, Lordship.
That affidavit was filed in 2022.
My former senior Justice UK Nair, so he was leading in this matter.
Counsel, please
lost
don't give me that.
Lordship,
Please
we
don't
lost
give me
contact
a
with
reason
the-
like that right now.
Lordship,
Huh? Please don't do that.
Lordship, much time has passed. The
Yes.
petitioner did not contact us, Lordship. we lost contact with the petitioner. Recently, the petitioner has contacted us.
Say
I
that.
would like to,
Say what is relevant. Don't say all
Lordship,
that.
Lordship,
22, the affidavit has been filed. We are in 25.
Lordship,
You want time, we will give you. But be reasonable when you
Lordship,
make a submission before the constitutional courts.
Lordship.
Yes,
Just the date may be fixed, Lordship, 1610, Lordship.
as heard MS?
D. Mohanton.
D, na?
D.
D. Mohantal, Learned Counsel appearing for the petitioner, also heard Mr. D. Upamanyu,
Yes,
Learned Standing Counsel,
Health and Family.
Health, so and so. Miss so and so seeks 2 weeks time. How much?
Lordship, immediately after the vacation. Lordship.
2 weeks time to file rejoinder to the affidavit in opposition filed by the respondent number 3 within bracket Health Department. It appears that the aforesaid return was submitted way back on 15/6/2022. Be that as it may, in view of the persistent prayer made, relist, give a date after vacation on such and such date. However, if the rejoinder is not filed by the next date of listing, the matter shall be proceeded in accordance with law.
Much obliged, Lord.
16.
Item number 3.
With pleasure, Lordship.
Yes, Mr. Bharadwaj.
The instant writ petition has been filed challenging the provincialization of the private respondents and also seeking amendments to provincialize
You are challenging the provincialization of the private respondents.
and also the provincialization of my services. Now, I have a limited prayer, Lordship, since what has divulged from the affidavit filed by the department. So my name appeared, I was appointed in 1994. My name appeared in the DICE data and also in the DICE data and also in the approval of my appointment.
What data?
DISC data.
DICE.
Yes. Well, in the year 2004, 5 and 11. Now, when the provincialization was carried out, my name was left out and the private respondents, 3 in number, along with the headmistress, they were provincialized. So I filed this writ petition. An interim order was granted, staying the operation of the provincialization, and subsequently it was vacated. Now the affidavit from the department has come. I will take your lordship to that particular affidavit. At page 99, your lordship, of that affidavit.
Page?
99, running page 99. This is by the Director of Elementary Education. Para 6. In the date of filing of the writ petition, I was never informed why my provincialization was not carried out. This is the first time I come to know. Now at page 99, para 6, your lordship, that the District Elementary Education Officer Sonitpur, with the recommendation of the District Scrutiny Committee Sonitpur, submitted proposal for provincialization of services as per Act 2017 against Poop Garimari Adarsha ME School.
Where are you reading at page 99?
Para 6, ma'am.
Yes. Yes, please.
Yes. The DEO Sonitpur, with the recommendation of the District Scrutiny Committee Sonitpur, submitted proposal for provincialization of services as per Act 2017 against Poop Garimari Adarsha ME School, in which the following 4 teachers were recommended, showing their enrollment position as 111 during 2016 to 17. Lalita Devi, Biren Bhuya, Siva Prasad Sharma, and Gopal Katil. That is me, the petitioner. And these 3 has been arrayed as private respondents. Based on the recommendation of the District Scrutiny Committee, the proposal as received from the DEO, Sonitpur, was placed before the state level scrutiny committee, followed by the joint committee constituted by the government. But as per the decision of the joint committee minutes dated 24/7/2020 constituted by the government, the office of the answering department verified all the parameters related to DICE data furnished by the SSA Assam and found that the name of the petitioner Gopal Katil does not appear in DICE data up to 2012. That is important. Therefore, due to
No, it says that based on the recommendation So showing the enrollment position as so and so during so and so. And what are these names? 1, 2, 3, 4?
My lord, the 1, 2, and 3 are the private respondents, and 4 is me, the petitioner.
Gopal
Kate.
Kate is the petitioner, and Lalita Devi is respondent number.
My lord, she is
Give me the respondent number.
7, man. 7, 8, and 9. 7, 8,
Yes.
and 9.
Based on the recommendation of so and so, the proposal as received from so and so was placed. So the proposal was for provincialization of these 4 teachers.
Yes.
Correct?
Yes.
Yes.
That means there's a 4th post.
4
available.
posts. But as per the decision of so and so, the office of the answer verified all the parameters and found that the name of the petitioner does not appear in DICE data up to 12.
Now, therefore,
What is a DICE data?
Mother, this is basically the inspection report.
It is
Information system for education.
district
Information system for education.
information system for education.
Data.
Yes.
The enrollment solution.
Okay. Yes, Mr.
Now,
Bharadwaj.
my lord, the last para.
Therefore,
Therefore, due to non-appearance of the name of the petitioner Gopal Katil in DICE data up to 2012, the state level selection committee as well as the joint committee could not recommend the name of the petitioner Gopal Katil against Poop Garima Adarsha ME School for provincialization against the Act of 2017. And the names of these
Yes.
teachers were,
ultimately what happened? DICE data?
my lord, what happened is, my lord, in those inspection
Because you see, I think you don't have any locus otherwise for the other 3 people because
Right.
their information is
that
there.
is where I'm going right now.
It appears that because of some technical hitch,
Exactly.
your name could not be considered for
But
provincialization.
happened?
I think this is what it is.
That is all. That is all. So what I'm
Then what is to be done now?
Lordship, kindly may take a lordship to
I
section.
come to you, Mr. Bharadwaj.
May I take a lordship to section 3111 of the 17 Act, lordship.
No, I want a solution. You
Lordship,
cannot deprive a petitioner because his data is you have not found his name in the DICE data. Who maintains the DICE data?
That is Sarva Shiksha Abhijan Mission.
Then if some lapses is committed on their part because his proposal had gone, that means you are not denying that he is not working. He is there.
Therefore,
Isn't it? Yes or not?
yes, lordship.
Now give me a solution before I open the book.
The first,
What is the solution?
First and foremost solution is there is a provision in section 14 of the 17 Act.
What does it say?
They can prefer an appeal before the appropriate authority.
Who is the appropriate authority?
In case of now, his case has been considered by the district level committee. Now it goes to the state level committee because state
So
level
he has to file the appeal before whom?
before the government.
Before the government.
Lordship.
Then you file the appeal, we can dispose
This is
it
what I
of.
have written down in my reply, my lord, against their affidavit. That is what I have written down in my reply. against-
So you file that
My lord,
and within a stipulated
that
period.
is my limited prayer.
Very well.
Lordship.
Why to open the book
And
and
in
get
the
into
meanwhile,
all
my
that?
lord,
I'm giving it, I'm disposing it of them.
Lordship.
You want to say something?
Yes, ma'am.
What do you want to say?
Problem is that-
You have a problem. What is your problem?
Problem is, my lord, we are already provincialized. But
That is not the concern of the court. A person petitioner has been deprived
my
for
lord,
no fault of his.
no. my
He
lord,
has been deprived because of
he
the
is
fault
deprived,
of.
but due to his
And
deprived, I
you
cannot-
see,
we
Mr.
cannot suffer.
Mr. Bora,
Cannot suffer.
Mr. Bora, there is a provision for appeal.
They may
He,
file appeal.
yes,
They
that
may
is
file
all
appeal,
this
no
court is
problem.
doing.
My prayer is that, my lord, your lordship, just a minute. We are due to pending of the writ petition, there is an interim order. Till today, we are not receiving salary, in spite of provincializing.
You are the private, you are one of the private.
Private as well.
So once this writ petition is disposed of, that order goes away. Well, where is the question?
Vacated, but till today, we are not.
No,
receiving.
that is, what can we be, have you filed a writ petition? Have you filed a separate application for your salaries?
But due to
That is
this-
not the issue involved here. Yes. Where in your reply, which paragraph?
My
Mr.
lord,
Bharadwaj, which paragraph?
in my reply, my lord, para 4, it starts 103, page 100. Para 4.
But dice code is mandatory as per rule. That may be.
Mr. Bora, you may take your seat. You are for the private respondent?
Yes. We are suffering from 2001.
The last paragraph, 104, Your Lordship, I have.
Yes.
That is my limited prayer.
Which is this provision?
Section 14 of the 2017 Act, Lordship, page number 123. 123 of this book, Lordship.
Page number 123. Appellate authority.
Lordship.
In your case, the district level committee did not.
No, Lordship.
Huh?
State level did not recommend. Therefore, they have to prefer the appeal before the government.
And the state government.
And the
Okay,
state
okay.
government, it's there.
All right. And the state government. All right. Heard Mr. P. Bharadwaj, P, right?
Yes.
Learned counsel appearing for the writ petitioner. Also heard Mr. P. N. Sharma, learned tending counsel, elementary education. And Mr. N. Bora, B-O-R-H, right? And Bora, learned counsel appearing for private respondent numbers 7, 8, 7, 8, 9, 8, 9, only 8 and 9, 8 and 9. Stop. By way of this petition under Article 226 of the Constitution of India, comma, the petitioner is seeking inter alia to consider the services of the petitioner for provincialization as the assistant teacher signs at Poop Gamiri Adarsha ME Vidyapith. Stop. The brief facts of the case is that the petitioner was appointed as assistant teacher science at the said school on 11/5/1994 by the respondent number 10 as per the resolution dated 12/3/1994 adopted by the managing committee of the said school. Stop. Accordingly, the petitioner joined as assistant teacher science with effect from 12/5/1994. Thereafter, on 2004, the district elementary education officer, Sonitpur Tejpur, inspected the said school and prepared an inspection note wherein these are not required, I think. No, this is not required. Thereafter, the school managing committee on 30/5/2017 submitted application for provincialization of services of teachers of the said school under the Assam Educational (provincialization of services of teachers) and Reorganization of Educational Institutions Act 2017, hereinafter referred to as the 2017 Act, before the respondent authorities, wherein the particulars wherein the petitioner was placed at serial number 4 wherein the petitioner placed at serial number 4 was, what do you mean was at serial number 4 and placed her name at serial number 1? In that list, she was 1 or 4?
But I was placed at 4.
Wherein the petitioner was placed at serial number 4, whereas the names of the private respondent numbers 789.
Yes.
789 were placed at serial number 1, 2, and 3 respectively. Stop. Which is that order where you showed the affidavit, na? However, the services of the petitioner was not provincialized, whereas the services of the private respondent number 7, 8, and 9 were provincialized. Situated thus, the present writ petition has been filed. Correct?
Yes.
Stop. Mr. P. Bharadwaj, learned so-and-so submits that it transpires from the affidavit in opposition filed by the filed on behalf of the respondent number 2 that the name of the petitioner having not been found in the DISC data up to 2012, the state level committee did not recommend the case of the petitioner for provincialization. Stop. He fairly submits that since the ground of non-provincializing the services of the petitioner is for not finding the name of the petitioner in DISC data up to 2012, the instant writ petition may be disposed of with a direction to approach the appellate authority as per section 14 of the 2017 Act. Stop. Mr. So-and-so submits that he has no objection if the instant petition is disposed of with a direction with the aforesaid direction as sought by so-and-so for he submits that he has no objection if the instant writ petition is directed by giving liberty to the petitioner to file appropriate to approach the appellate remedy as provided under the 2017 Act. Stop. Mr. N. Bora, learned so-and-so, appearing for the private respondent number 8 and 9, submits that in view of the interim orders ultimately vacated. In view of the interim orders passed in the instant writ petition, though later on was vacated, however, the respondents have not yet received their salaries. Stop. I have given my anxious considerations to the arguments advanced by the learned counsels appearing for the parties and have perused the materials available on record. Apt at the outset to refer to the relevant paragraphs of the affidavit in opposition filed by the respondent number 2 on 19/2/2025, which reads as hereunder. In paragraph 6 at page 99, huh? We'll take paragraph 6 to read it. Reading of the aforesaid paragraph, it is apparent that due to non-appearance of the name of the petitioner in DISC data up to 2012, the State Selection Committee as well as the Joint Committee could not recommend the name of the petitioner against Poop Gameri Adarsha ME School for provincialization of his services as per the Act 2017. Stop. It appears that no, don't say all that. Huh? It appears that Section 14 of the so-and-so Act 2017 provides an appeal against the order passed by the State Level Scrutiny Committee, which reads as hereunder, quote unquote, Section 14. In view of the aforesaid appellate provision, without adverting into the merits, this court deems appropriate in the interest of justice to dispose of the instant writ petition by giving liberty to the petitioner to file an appeal before the appellate authority in terms of Section 14 of the Act 2017, and as and when such appeal is filed, the same may be disposed of, same may be considered and disposed of by the appellate authority within a period of
2 months, Lordship. 2 months is required.
2 months is too long.
Probably because from the date of receipt of the
Within a period of 2
appeal
months from the date of receipt of the certified copy of the order.
By affording me a hearing.
In terms of the principles of natural justice, in accordance with law, ordered accordingly, disposed of.
One is.
IA stands, IA is there.
That was again one stay vacating application that was not.
IA accordingly
One
disposed
line may be given, my lord, to
in
the
view of so and so.
pendency of the appeal, my lord, before the authority, there is no, my lord, regarding salaries concerned.
Salary.
But our salary was not paid, my lord.
Why that direction is required here?
No, I'm not,
We are
I'm not asking the direction.
No, but I have
No
already.
word to releasing the salary.
It is needless to be clarified that the it is where is that order, that stay order? Show me that stay order, which has been vacated.
Order dated 31/3/2021. This is the entry.
Order dated
31 and order dated 4/4/2025.
4/4. Yes. There is already an order on 4/4 having considered the submission of letter standing counsel and letter counsel so and so, the respondent may consider payment of their salary if the respondent 8/9 are being allowed to work as teachers. What more orders you want, Mr.?
No, my lord,
Huh?
otherwise, my they're
This order is there. If they're not releasing, file a contempt. Why are you not filing a contempt? There is an order.
my lord.
Well, what more order you need?
That the authority may consider, my lord, not my lord. Thereby then.
Yes.
Item number 4.
In respect to item number 4 also, after reserving the judgment, that matter was come up.
That matter was finally
Sorry?
heard. That particular matter was finally heard by the Honorable Court number 2 lordship.
Don't specify
Lordship.
by another court.
Another court.
Yes.
And after that, for the first time.
So again, it has come for the first time. So so you are not prepared. Understandable. Mr. Chaudhary, I don't think he's going to object to your prayer.
I'll not object, my lord, but I'll pray for
Some urgency.
I'll pray for him, my lord.
Yes, you all suggest a date. We will have it on that
After-
date.
after vacation.
Please come up with a consent date. Heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. P. Chakraborty, Learned Counsel for the petitioner. Also heard Mr. K. Gogoi, Learned.
I'm a counsel for the chancellor also.
And I'm.
That's why I'm asking Learned. You have a lot of titles. Learned? Learned what? You're Learned Counsel for?
Counsel for ZU also.
For?
ZU.
GU.
Both university.
For Learned Counsel appearing for the Guwahati University, stroke respondent number
That's from the 1 also.
1. And Mr. PJ Fukan,
Respondent number 2 to 5.
Learned Counsel appearing for respondent numbers
2 to 5.
2 to 5. It is submitted at the bar that since this matter, after being reserved for judgment for exigencies having been released, has been listed suddenly today, some accommodation may be given, may be allowed. Relist on such and such date.
16 lordship.
All right.
16 October.
Why is it so voluminous?
My lord, the
Issue is small.
But
Then you have a synopsis if it is not already there.
Lordship, written argument is also inside the file, lordship. Both sides.
already written arguments on both sides are on record.
Ketya fix correlator?
16th.
16.
Can it be Millard on 23rd Millard? Okay.
23rd also.
I am waiting for Mr. Chaudhary to tell me.
27. I'll
All right.
I'll not object to that.
All right. All right. Next.
Item number 5.
May it please your lordship, here in this case, my lord, I have filed an interlocutory application
Yes.
for substitution of the petition number 2, my
The
lord.
IA is not there.
It's
Yes, my lord, in the
IA.
1267 of 23.
12767, my lord. 27.
Whom you want to bring on record?
My lord, bring on record, means, my lord, during the pendency of this case, the petitioner number 2 died, my lord. So in his place, my lord,
Legal air.
yes,
Heard Mr.
R. Islam.
Al Islam counsel appearing for the applicants. Top also heard Mr. D. Upamanyu, Learned Counsel appearing for
1, 4 and 5 higher education. 1, 4 and 5
1, 4 and 5.
higher education.
Higher education, Standing Counsel Higher Education. And Mr.
B.A. Kayyum.
So and so Learned Counsel appearing for
Number 6 and 7.
6 and 7. By way of this application, comma, the applicant is seeking substitution of the applicant in the writ petition as writ petitioner number 2. Full stop. In the writ petition IEWPC number 7368/2024 as the petitioner number 2 expired during the pendency of the writ proceedings. Stop. It appears that during the pendency of the instant writ petition, the husband of the writ petitioner number 2 in the connected writ petition died on 18/7/2023, leaving behind the applicant and 3 daughters and 1 son. Since the 3 daughters has already got married and the remaining daughter and son are minor, the present applicant has filed the instant application for substituting her as the legal heir of the writ petitioner number 2 in the connected writ petition. Peruse the averments made in the interlocutory application in support of the prayer for substitution. Having it appears that in view of the it appears that the right to sue is having been continued and the applicant is the legal heir of so and so. The prayer stands allowed. Let so and so be substituted in the place of writ petitioner number 2 in WPC number so and so. Stands allowed. Register let an amended cost title.
Yes, sir.
Let an amended cost title be submitted before the registry for doing the needful. Disposed of.
Much.
Item number 7.
This matter was also heard at length before a different court. And the judgment was reserved. We also gave the written arguments. And
Another date.
I think it will be better because, my lord, in this matter.
Okay. Heard Mr. A.K. Barwan, Learned Counsel appearing for the petitioner. Also heard M.S.A. Gayan, Learned Counsel appearing for respondent numbers 1, 2, 3. It is submitted at the bar that since this matter has suddenly been listed today after being released from CAV by another bench, relist on such and such date. Give a date.
23rd October.
All right.
No, there's an interim protection.
Interim, if any, shall continue till the next date of listing.
Public.
9 and 10.
Area salary.
Lordship, kindly for the time being.
Time being. But what about the counter affidavit?
Lordship, the instructions are awaited, your lordship.
Why?
Lordship, the.
Since
last-
when areas, find somebody. Since when the salary has not been given?
Lordship, here.
Yes, by when? When can you have the counter affidavit ready? Because I think return is required.
Yes, your lordship. However, we have decisions of the Honorable Division Bench, your lordship, where they say that where the services of teachers who were appointed.
Are you filing or you're not filing?
Lordship will file.
If this court is not going to force you to file, Ms. Musari, you don't look very happy to file. So I am only asking a very simple question.
After 2 weeks, your lordship.
As prayed for by M. D. Musari, Learned Counsel appearing for
Secondary education.
Standing Counsel Secondary Education, relist after 2 weeks on a date to be fixed by the registry to enable the department file return in the matter.
Please, Lordship.
Item number 11.
Yes, Mr. Jha?
Lordships,
11. What about counter?
Lord, instruction is awaited, my lord. 1 week's time maybe, lord.
24 matter. All right.
Record may be called for your lordship from the your office.
But you are BTC.
Yeah.
There is already an order
Yes, my lord.
that if BTC does not file, the matter shall proceed in accordance with law. Why are you not filing?
My lord, in
Who wants to file?
my lord,
Who is the officer?
1 week time maybe allowed.
I will give you the 1 week's time, but who is the hearing officer? Who has not filed? Who is not giving you the instructions?
My lord, in earlier occasion 13, it was.
I'm asking you who is supposed to give you the
My lord,
instructions.
that instruction to be given by.
All right.
Yes,
Heard Mr. N. Jha, Learned Counsel for the petitioner. Also heard Mr.
P. Hazarika,
P. Hajorika, Learned Standing Counsel BTC.
on behalf of SRF.
And are you standing counsel or you're not standing
No,
counsel?
not.
Learned Counsel appearing on behalf of the standing counsel BTC. And Mr. D. Bora, Learned Counsel appearing for respondent number 1 and 2. It appears that despite being clarified by this court's last order, dated 13/8/2025, no affidavit in opposition has been filed today by the BTC. In fact, the Mr. So-and-so seeks further time to file the return. Be it as it may, relist on such and such date, and they give after 2 weeks, on such and such date. In the event the return is not filed by that date, the erring respondent shall be personally present before this court.
Item number 12 and 13.
Yes.
Lordship. In this petition, Lordship, I am challenging the selection and appointment of private respondent number 7 as the headmistress of the concerned school.
What is the ground of challenge?
Lordship, I am senior to respondent number 7. And in violation of Rule 14 of the Assam Secondary Education Organized School Service Rules 2018, the senior most teacher has to be appointed as headmistress. The selection committee has gone ahead by allotting some marks based on the interview itself and has appointed respondent number 7 as the headmistress. I had challenged on day 1, there was an interim where I was allowed to continue, and till date I am continuing as in charge headmistress of the Sage School. So my point of challenge is the appointment letter as well as the selection committee minute, based on which the private respondent number 7 has been selected.
This was a person to some advertisement.
No. A
Promotion.
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 Yes, because the headmaster post was vacant because of the
You were holding the post of teacher.
assistant teacher.
Assistant teacher.
Then I was posted as in charge headmistress when the original headmaster has retired.
But in charge doesn't give you any right.
No, it doesn't.
Now they have finally promoted the respondent number 7. 7.
Yes.
Is the respondent number 7 senior to you?
No, junior to me.
And the rule says merit cum seniority?
Seniority comment.
Seniority cum merit. What is the stand of the state government, the department?
State government says that based on the interview, the marks which was allotted to respondent as 7 is higher than marks allotted to me.
But what and the rule can the rule says seniority.
Seniority.
But then of course you have secured less mark.
But only based
Senior merit cannot be cannot be overlooked.
The rule says,
If you have admittedly secured less mark.
Lordship, but the thing is, as per the rule, the seniority comes first, and they also have
Only
certain
when
ACRs.
merits are same. You have to have the same merits, then only
But they
the
have to
seniority will
consider
come.
ACRs as
I
well,
think
Lordship. They have to consider the ACRs as well, but they have not considered the ACRs. That is my specific pleading.
what is yes, who's appearing for the other side?
I am appearing for response.
I'm trying to understand.
But if I may take your lordship to the prayer.
No, yes, tell me.
Prayer is the petitioner herein has challenged the entire select list. But so far as the annexure is concerned, the petitioner has only annexed this advertisement selection list of Kokrajhar district. The entire Udalguri district seniority was calculated and the assessment was made as per the rule. Interviews were held, and in the interview, based upon the performance and the marks, I was given the promotion. It is not for the single school; it is for the entire district. Well, the petitioner, the claiming here only the violation of Rule 14 of the rule of 2018. The 2018 rule.
What is Rule 14?
The 2014 rule doesn't say, well, it lays down the entire procedure. The vacancies would be assessed by the inspector of schools. Then the list will
Anyway,
be.
I'll admit this matter.
And
it will need some hearing.
And the select committees are not before this honorable court.
That
the
will
district level committee and the state
if
level.
they don't want to bring Mr. Nayak, you're also there. We'll admit it. It will need some hearing.
Otherwise, respondent number 7 also getting the
We have not received this alert since 1 year.
Dr. A. Tori, Lordship.
You are a private respondent.
Yes,
Oh, you are the private respondent.
Yes.
How come you have you came before the I thought you are representing one of the department. I wanted to know the stand of the department. Anyway, heard Mr.
Dr. A. Tori, Lordship.
So and so Learned Counsel appearing for the petitioner. Also heard Mr. P. Nayak. Learned Standing Counsel BTC and P. Sharma. P.N. Sharma, Learned Standing Counsel Elementary Education, and Mr.
As Biswas.
S.
Biswas.
Vishwas, Learned Counsel appearing for private respondent number 7. It appears that the pleadings are complete. It further appears that the matter requires full-fledged hearing. Admit no formal notice as parties are represented. Relist for hearing. When?
After vacation.
in the month of November 2025 on any date to be fixed by the registry.
Well, there is another case, well, next item, contempt case for non-payment of the salary. Well, he is the disbursing authority. And though there is a direction, clear direction from the court that there is no bar in releasing the salary.
Item?
Item 13.
Sound
13,
13.
connected matter.
There is a correspondence dated 7 September 2024 for releasing the salary. But since he is holding the
Notice has been issued, yes?
Yes.
Contempt, who's appearing? Who's appearing for respondents, contemptness? No, but are you appearing in this matter in the contempt proceeding, Mr. Nayak?
Yes.
Are you appearing for respondent numbers 1, 2, and 3?
I am for 3.
You are appearing for
Petitioner
3.
made as contempt number 3.
So are you all not going to file anything in your contempt petition? If you're not interested in filing, we shall hear the contempt.
We'll file lordship. Actually, the writ petition was taken along.
I am not interested in that. There is a contempt proceeding pending before this court.
Lordship.
Are you filing your show-cause? You have received a notice from the
We have
court.
received notice.
In response to that notice, are you filing any response before the court or not?
We'll be filing it, lordship.
Then please file it.
But there is a direction from the department to the petitioner to release the salary.
So where is that? That
Your lordship may kindly look at the web marked it with green flag. 7 September 2024 in the IA.
There is an IA also.
Yes. In the main case, there is an IA. The correspondence dated 7 September 2024.
Why are you not releasing it, Mr. Todi?
Lordship, because the private respondent number 7 is not discharging the function of the head.
There is a direction. Why are you not doing?
Direction was the lordship.
You file your reply. Otherwise, we'll have to ask him, the person concerned, to be personally present. Heard Mr. As Biswas, Learned Counsel appearing for the petitioner. Also heard Mr. A. Todi, Learned Counsel appearing for 3. And 1 and 2, Mr. Nayak. Mr. P. Nayak for 1 and Mr. Chalia for 2. For 2. Yes, I'll say 2 weeks for everyone. As prayed for by the learned counsels appearing for the contemptness, relist after 2 weeks on a date to be fixed by the registry to enable the contemptness file return in the matter. Relist after 2 weeks on a date to be fixed by the registry. This I am not keeping it with that because this is a separate proceeding. DTAC Puridiba. Yes, next. IA is in the contempt.
IA is the main writ petition.
IA to main petitioner. But Mr. Biswas, you bring that in the in the contempt
Yes.
Otherwise we will not get the file. IA to return lagot thoba or contempt to belek kore diba.
Much of
No, otherwise you see the contempt will keep
Yes.
will go to the month of
Yes.
November. So that is why I have expedited the contempt.
I am obliged. Ready.
14, 15 and 16.
Yes, Mr. Pathak.
It pertains to pay parity for vocational teachers.
Yes.
Now, the posts were divided in such a manner that initially, my lord, around 274 persons, my lord, they were regularized in a pay scale of 5,400, whereas because there were posts not available at that juncture, we were regularized, my lord, in a pay scale of 2,400. So there was, though we are doing the same work, my lord, there is a great disparity in pay. There was the 7 CPC report, which then said that we would be placed in rupees 3,300 with 3 increments. My lord, that also has not been implemented, my lord. As of now, the
affidavit's filed.
Lordship, we have filed our affidavit.
The director has filed, my lord, but then since the question of sanction of this additional
Who has to file?
provision is there, the finance is also a party here.
Finance, Mr. Chalia.
Finance has not, my lord, filed anything. The position. I think in 16 finance.
Yes, Lordship.
Yes, what about the other items?
Lordship, it will be similar. They are similar.
Then give a copy to Mr. Pathak. Mr. Pathak doesn't have a copy.
Lordship,
Huh?
yes, yes.
If your stand is that the counter affidavit filed in item number 16 is going to cover all the cases, then you give a copy to the clerk councils appearing in the other items.
Lordship, I was not aware.
They cannot be taken by way of a surprise.
Lordship,
All right. Heard Mr. B. Pathak you are in WPC 2121 of 2024?
20, item 14.
And then what about Mr. Deka? You are in
Item 15.
R Deka, na? RN?
RM.
RM or N?
M.
M
Mallo.
for Manipur.
Yes.
RM Deka, Learned Council appearing in WPC 3838 of 2024 and next one.
2890.
So and so. And Mr. M. Hussain, item 16. Also heard Mr. H. Halia, Learned Council appearing for Standing Council in Finance Department. And MS D. Mushahari, Learned Standing Council, Secondary Education. Mr. Chalia submits that an affidavit in opposition has been filed in item number 16. How?
2890 and 4517 we have filed our affidavits.
Items.
Item, Lordship.
2890.
I have the copy with me, Lordship. Yes, item number 16 I have filed and item number 15 I have filed.
In item number 15 and 16, and the same affidavit shall also cover
Item number
the
14.
case of the petitioner in item number 14. WPC. However, a copy of the said affidavit has not been furnished to Mr. V. Pathak, Learned Counsel appearing for the petitioner in item number 14. Let a copy be also furnished to so and so. Relist, yes, when?
21st. 21st.
On such and such date. In the meantime, if the Learned Counsel for petitioner, in the meantime, the petitioners are at liberty, if so advised, to file rejoinder to the affidavit of opposition filed by the Finance Department.
Can you 23rd? 21 is the holiday.
All right, all right.
23rd. Reply of license.
Yes.
So in this case, there is a direction to the respondent side to file their affidavit.
Similar matter, Lordship.
They are insisting on the matter that their cases, the part by elimination, therefore matter will be dismissed. But
They are not having insisted anything. They have not said a word.
No, Lordship. On earlier occasions.
I do not remember what happened in fact, this court, this is the first time it's coming before this court.
Yes, Lordship.
Then how do you expect this court to know what happened in another court? Huh? Yes.
This is a case that the petitioner, he appeared in a examination for constable in the GD conducted by the SSC. So he scored more marks than the last selected general category candidates. But he was not, his name did not appear in the select list. In similar other several cases, this court, honorable court.
Your name did not appear in the select list.
Yes. So
your relief is what?
I want that I may be selected and
what is the what is your legal claim?
My legal claim, your lordship may see. I applied under the OBC category. So, but I did not take any relaxation given to the OBC. Therefore, the marks I scored, I may be treated as unreserved candidate. So, if the last unreserved candidate gets some marks, I score more marks than that person. So, I may be treated as an unreserved candidate, I may be given the election.
Yes, you wanted to say something?
Lordship, this advertisement issued on 2018 and thereafter select list was published on 2021. And in similar matters, Lordship, Honorable Court has already passed dismissal order on dismiss this petition on delay and effect grounds. Several cases.
Advertisement is when?
2018, Lordship.
And select list is?
Select list 21.
Its select list stands valid till because of that ground or delay?
Delay ground, Lordship.
And it is challenged in 24.
Yes, 24. And before that, before filing this writ petition, already Honorable Court dismissed other writ petitions, Lordship. This is the first living case, Sajal Ali.
Is this the same advertisement?
Yes, sir.
Same advertisement, same select list.
Even
That's why he was so apprehensive. Huh?
Even your honor also passed an order, but
Huh?
I have,
Huh?
your honor, have also
This
passed an.
court has also
or
authored.
This court.
Where is that?
That I have not, now, like, say.
Yes, paragraph 4 is your submission. You've just submitted that. This is the petitioner's claim in this case. And you have submitted the same. Then,
Except only one thing, this petitioner was eligible to get the selection. Now the authority has not selected him, and the thing is that
no, delay.
Lordship,
All right.
if third party's right is not affected, then the petition may not.
All right. Heard Mr.
Arsenal.
R. Sharma, led counsel for the petitioners. Also heard MS S. Barua, BARUH.
Yes.
Led Central Government Council.
Yes.
Appearing for the respondents. Stop. By filing this, by way of this writ petition under Article 226 of the Constitution of India, the petitioner, how many petitioner?
One single.
The petitioner is seeking quashing of the result of the select list dated 21/1/2021 in respect of recruitment of constables within bracket GD in Central Armed Force, in Central Armed Police Force within bracket CAPFs, NIA and SSF and riflemen within bracket GD in Assam Rifles 2018. Correct?
Yes.
And for a direction to the respondent authorities to publish a fresh revised select list in respect of state of Assam by treating the candidature of the petitioner in the unreserved candidates category. Correct?
Yes.
Stop. The learned counsel The Learned Central Government Council has submitted, and as per the instructions received by her, all the posts advertised has been filled up, and resultantly there are no vacancies for considering the appointment of the petitioners. She further submits that in a series of writ petitions, in a series of similarly situated writ petitions, the coordinate bench of this court has already dismissed the prayer made by the petitioner in the instant writ petition on the grounds of delay. Stop. She accordingly relies upon the following decisions of the coordinate bench 1, 2, 3. Next para. The petitioners claim that they holding to the OBC category, and they claim that they have secured more marks than the last candidate in the unreserved category. Accordingly, the petitioners claim that they are entitled for appointment in the said post. Mr. So-and-so submits that under similar circumstances in another writ petition, notice of motion. Are you saying that now? I think that is already gone. No, don't say that. Huh? It is an admitted fact that
in several cases
it is an admitted fact that the advertisement in that the advertisement was issued on 21/7/2018. Correct?
Yes.
2018. And the select list was published on so-and-so 21. I had to put a select list dated on so-and-so 21.
2021.
On so-and-so. And the present writ petition has been filed
August 2024.
on when?
9th of August.
16 8/24.
On 16/8/2024. There appears gross delay, and on this ground alone, the present petition is not maintainable. It further appears that the post advertised has already been filled up. Accordingly, in this court, this court is in respectful agreement with the coordinate bench, with the decisions of the coordinate bench in so and so, so and so. Accordingly, this court does not find any merit in this writ petition, and the writ petition stands dismissed on grounds of delay and laches.
Problem.
Disposed of. Into your test. Tick mark করে দিস।
Item 19.
Yes.
May please, matter relates to fixation of pay of the petitioner, lordship. In this case, lordship, respondent has already filed affidavit, lordship. And I have also filed reply, lordship. So may I pray that lordship kindly fix the matter after vacation, any hearing day, lordship, for this final disposal? Because
Pay
petitioner,
parity.
yes, petitioner
Pay
retired, lordship, in the month of December 2020.
Third, P. Bhattacharjee,
Yes.
learned counsel appearing for the petitioner, also heard MSR Barua, learned counsel
For the respondent's lordship, on behalf of the learned advocate general lordship.
learned counsel appearing on behalf of the learned advocate general, state of Assam, for the state respondents, and Mr.
SP Das, madam.
SP Das,
For respondent number 6, 7,
learned
8.
counsel appearing for respondent number
6, 7, and 8.
6, 7, and 8. It appears that the pleadings are complete. It further appears that the petitioner has made out, it further appears that the matter requires full-fledged hearing. Admit no formal notice as parties are represented. Relist for hearing in the month of October 2025 on any date to be fixed by the registry. Not October, November.
Then lordship kindly fix a date, lordship.
Welcome, Ms. Bhattacharjee, not to worry. November. October will be reopening and you have retired. Yes.
Item 20.
Grievance of the petitioner has already been met by the office of the AG, my lord. Everything. That's why probably they are not appearing. The last occasion also had.
Yes, there is no one. Very well.
And this
No one appears for the petitioner on call. Heard Mr. B. Sharma,
for the
learned counsel appearing for respondent number
2, accountant
2, and Mr. D. Barua, D. Bora, learned counsel appearing for respondent number
1 and 3.
1 and 3. It appears that on the last occasion, I-26/8/2025, as well, there was no representation on behalf of the petitioner. Today also, despite the name of the learned counsel appearing in the cause list, there is no representation on behalf of the petitioner. Mr. B. Sharma places the.
This is not my instruction.
No, what is this?
Basically, PPO, the name of the petitioner's name has to be entered in the PPO.
And that has been done.
That has been done.
This is my instruction. That is his mind.
That is mine.
Mr. B. Sharma, learned counsel appearing for so and so, submits that upon receiving the letter from the Assistant Inspector General of Police, Law, Assam, for including the name of the petitioner in the PPO book of late Nobin Sinha, EX-ABC within bracket LNK of 6th AP Battalion, Kathal, Assam, comma. The senior accounts officer, legal cell of Of which department?
Office of the Principal Accountant General.
Of so and so?
I say that the Office of the Principal Accountant General.
Office of the Principal
Accountant
General
had directed.
has directed the Treasury Officer, है ना?
Yes, ma'am.
To Treasury Officer Kachar Silchar to include the name of the petitioner as second wife in the PPO of her deceased husband, treating the letter as an authority. That being so, nothing survives for adjudication in the writ petition. In view of the aforesaid, and then the letter, the communications dated 5/10/2024 and 21/10/2024 are kept on record and marked as A and B, X and Y, X and Z, sorry. In view of the aforesaid, nothing's the writ petition stands dismissed on being infractious.
21.
Yes, area salary affidavit.
My lord, we have filed affidavit.
Yes, Mr. Dhar.
My lord, I think I'll have to take further instructions because in our affidavit in para 8, we stated that, my lord, that
we have order seems to have been passed by this court. R. Barpujari is there. Yes, Mr. Chalia, you were supposed to obtain specific instruction as regards the status of the subject sanction and place the same before this court on the next date of listing. You are not aware. So take instruction. When can we have it?
Lordship, after 10 days, Lordship.
Heard Mr. F.J. Majumdar, learned counsel appearing for the writ petitioner. Also heard Mr. R. Dhar, learned additional senior government advocate appearing for the state respondent, and Mr. A. Chalyan, learned counsel appearing for the newly impleted respondent number 4. Correct? Stop. Mr. Chalyan seeks a short accommodation in order to place the status report of the subject sanction as called for, as directed earlier by this court by order dated 13/8/2025. Prayer is allowed, released on such and such date. Yes, give a date. No, before vacation.
24 September. Until 22.
Maybe. Yes.
Yes.
Area promotion of benefit mandate.
Yes.
This is the last 7/8 order mandate.
This is
7/8 order mandate.
yes, positive instruction.
Yes, Malad. I have received an instruction, Malad, yesterday. As per that instruction, fresh proposal has been called for the district officer, Malad. Fresh proposal has been sought from the district officer, my lord.
So
It has not come till now, my lord.
when will that come? And what was the occasion for fresh proposal?
Because there are some miscalculation regarding DA, my lord.
All right, then you have the up-to-date
Yes, ma'am.
status.
Before vacation, so that I can
Heard Mr.
S. Rahman.
So S. Rahman, learned counsel appearing for the writ petitioner. Also heard Mr. N.J. Khatoniar,
Yes, madam.
learned counsel, standing counsel, appearing for the elementary education department. অকমান এই ড্রাফটটো এফালে বন্ধ কৰাই গেছে Mr. Khatoniar submits that as per the instructions received, a fresh proposal has been sought
From the district office.
from the
DEO Dhuburi, my lord.
DO District Officer Dhubri.
Dhuburi. District Elementary Education Officer Dhuburi.
District Elementary. Stop. In view of the same, let the up-to-date status report be placed before this court on the next date of listing, relist on such and such date.
22nd of late lordship.
Affidavit, Mr. Talukdar.
My lord, in this matter, my lord, I am sorry, my lord, we are seeking lots of time for filing affidavit, my lord.
Please, Lordship. In this case, all the petitioners are LP school teacher and they are claiming the benefit of old pension scheme.
How much more?
My lord, yesterday I have received a instruction, my lord, as per my instruction, my lord, the entire matter
looked into the by the finance department in whole Assam, my lord. So already finance department has seeking some instruction from the department, my lord. We have already
Wait, wait. So you have already sent that. Where is Mr. Chalia gone? Finance. Finance a party here or not?
Yes.
Yes, yes.
Who's there for finance?
See, it is a covered case. In similar cases, Honorable Court give direction to provide benefit of old pension scheme. Lordship, we annex the copies also.
Where? Which page?
Page 65, my lord. Purnima Ore judgment, lord. But
On two judgment we annex, Lordship. Annexer 68, page 65. And Annexer 9, page 161, Lordship.
And annexure?
Page 161.
Mr. Talukdar, it's covered.
covered, my lord, but problem is that
Covered, then what but?
because my lord, the matter
Huh?
that matter
If it's covered, I'll dispose it of in similar. Similarly.
my lord, in Purnima Ore case, my lord, the old pension is given to the stipendiary teacher. Here, my lord, the petitioner appointed as assistant teacher on the basis of honorable court order, my lord, in the year 2009, my lord.
Anyway, finance not there. Heard MS
Ardeka.
Ardeka, Learned Counsel appearing for the petitioner, also heard Mr. B. Talukdar, Learned Standing Counsel, Elementary Education Department. None appears for the finance department on call. Mr. Talukdar submits that as per the instructions received, the
entire matter looked by the finance department, and they sought for some list from the department. Accordingly, we have submitted the list of teacher, my lord.
that the entire matter is being looked after by the finance department, and as per the instruction, as per the information sought for
my lord,
from the finance department, the elementary education department has already furnished the same.
Same on 6/8/2020.
On 6/8
2025.
6/8/2025.
My lord.
Stop. Huh? Mr. Chalia is there. Don't say none. Chalia Finance. In view, let a copy of the aforesaid instructions be placed on record by way of an affidavit. In the meantime, let finance also file their return in the matter. Relist after 2 weeks on a date to be fixed by the registry. In the just one sec, in the affidavits, let the learned counsels appearing for the respondent further obtain instruction as whether the case of the petitioner is covered by the judgments of the coordinate bench of this court in so and so and so and so. Page number 1.
Page number 161.
161 and 90 something you said?
65.
And 65. Okay.
I've received my instructions a few minutes ago, Your Lordship, so I made.
All right, fair enough. 2 minutes ago. As prayed for by MS, so and so learned counsel appearing for the respondent to the effect that the instructions have been received 2 minutes ago. Just a few minutes ago, relist after so and so 2 weeks on a date to be fixed by the registry to enable the department file return in the matter.
Date may be fixed, ma'am.
It'll come. It'll come. Next.
25.
Lordship, here in this matter, Lordship, I'm seeking for 2 weeks.
As prayed for by Mr. D. Upamanyu, learned counsel appearing for the
Higher education.
learned standing counsel
1 and 2.
so and so relist after 2 weeks on a date to be fixed by the registry to enable the department file return in the matter.
College authority also required to file affidavit.
As
per number 3 and 4.
You also file. In the meantime, in the meantime, the remaining respondents are also at liberty, if so advised, to file their return.
Relating fixation of payment, he's going to return on.
Next.
Obliging.
Item 26.
Wait, please, Sir Lordship. Lordship, what you take time?
Huh?
Some time to file our affidavit, Lordship.
You want time to file affidavit? 85 matter, okay. Heard Mr. So and so, learned counsel appearing for the petitioner, also heard MS.
As compared.
As compared, learned standing counsel.
Yes, Lordship.
Standing
2 to
counsel
5.
KAC.
Yes, sir.
KAC. And Mr. Dhar, learned standing counsel PWP. Mr. MS so and so seeks 2 weeks time to file return in the matter. Prayer is allowed. What about Mr. Dhar?
Let them file, my lord. Go.
What is let them file? Why you want them to file and then you to file? Why can't you file?
So, my lord, the thing is that
So and so, a prayer is allowed, released after so and so. In the meantime, the remaining respondents are also at liberty, if so advised, to file their return.
27.
May I please, Lordship? Petition pertaining to Lordship, a promotion to the
Yes,
post of headmaster, Lordship.
yes, yes.
I'm appearing on behalf of RB Bora, season Lex Lordship. Kindly pass the word for time.
As prayed for, released on Monday. On Monday.
On 15.
Yes.
Item 28.
Yes, Mr. Chaudhary.
My lord, here in this case also, my lord, affidavit in opposition.
Not filed.
It's not filed, my lord. It will be required, my lord.
Yes.
This whole time, my lord, we have approached this honorable court.
Yes. Who's appearing for the respondent? Mr. M.K. Chaudhary. No. Yes. This also, that DISC.
My lord.
Who's appearing for the respondent?
Preparing, Your Lordship. Instructions is awaited, Your Lordship.
Heard Mr. M.H. No?
Mine.
Mr. M.H. Chaudhary, learned senior counsel, assisted by Mr. TL. Chaudhary, learned counsel, appearing for the petitioner. Also heard MS so and so, learned counsel, appearing for the
1, 2, and
learned standing counsel. Huh?
Yes, sir.
Standing counsel, secondary education. MS so and so seeks how much time?
2 weeks more time.
2 weeks, further 2 weeks time to file return in the matter. Prayer is not opposed, released after 2 weeks on a date to be fixed by the registrar.
My lord, my lord, it's regarding item number 43 and 44, my lord. The mentioning time, my lord, it was adjourned for 2 weeks, my lord. So
It's already
obviously,
passed.
my lord, can it be on for 1 week, my lord? Most obliged.
ভাল লগা নাই কবলৈ মেনশন উইমে দিম আৰু
The petitioner's work order was wrongly recorded as work order letter so and so in place of so and so. It's page 7, not my underline queries. Okay. That being so, the judgment in order dated so and so is corrected to that extent of the petitioner's work order shall now be read as so and so to quote allowed. This will form part of this. Okay, disposed of.
For hearing item number 46.
My pleasure, Lord. My lord, in this case, some development took place, my lord. Today, my lord, we have moved, my lord, a similar petition. Those petitioners are the part of the present writ petition. During the pendency of the writ petition, despite the interim order, they were removed from service. So fresh cause of action arose, we filed a writ petition. Today, my lord was pleased to issue notice, making the returnable within 4 weeks.
Where? Those other man?
Other.
Yes.
Honorable Justice Manish Chaudhary.
Today,
Today,
No,
and I
so
can-
you want to withdraw this?
no, both the matter may be tacked together and heard.
No, that only notice have been issued.
Yes,
When is those matters fixed?
my lord, returnable, making returnable within 4 weeks.
All right, then we will adjourn this.
My lord.
Heard Mr. A.K. Prakasta, Learned Counsel for the petitioner. Also heard Ms. A. Gayan, Learned Counsel, appearing for respondent number so and so. It is submitted at the bar that during the pendency of the writ petition, the petitioners have been removed from service.
Yes.
And accordingly
They filed a writ
fresh writ petitions. And accordingly, a fresh cause of action having been arisen, they have already filed writ petition before this court being so and so.
5309. WPC 5309 of 2025.
Today, item number?
Item number 19.
Court number 6.
21, court 6. So and so. In view of the said development, relist along with so and so. So it will come with that.
After, yes.
Huh? But that will take it. Okay.
Obliged, Lord.